areas at no cost to them. Today is the third day of the intellectual property series of the TPTA trainings. And I'm happy to observe that in the last 2 days, we've had more than 2,000 participants at the trainings. The training is, of course, MBA ICLE accredited. And I want to inform everybody that the MBA ICLE has just released some new rules around the issue of CPD points. So everyone who's on this Zoom platform today participating in the training doesn't need to fill up any link or anything. The report from the session, the Zoom report from the session, would account for the source for the names and details of those who attended the meeting. So that will be our attendance register. So we've observed that over time, people tend to send their names and details on the chat box. So we're going to freeze the chat box for today so that we don't have this distraction going on until people get used to the idea that they don't really need to post that on the chat box. But we, of course, expect people to raise issues and questions in the Q&A box. On the chat box, however, we're going to have the link, YouTube link for the training and indeed for the TPTA on it. And we encourage as many people as possible to subscribe to the TPTA YouTube channel, because that's where we have all our videos stored and you can access them at any time at no cost. So thank you very much. Today is the other trainings have been very well received. And today, Module 3 will be looking at enforcement, emerging issues and opportunities in IP law. My role today would be to introduce the facilitator for today, and then I would let Nta Ebiken Mbang then moderate the sessions going forward. It is a privilege and indeed an honor today to introduce Mr. Obafemi Agaba, who is the facilitator for today's session. Femi Agaba is a partner at Jackson A.T. and Edu, a leading Pan-African full-service commercial law firm with a sector focus. Obafemi heads the litigation and dispute resolution practice group of the firm. He's an expert in diverse areas of complex labor and employment disputes, including trade disputes and compensation claims in court. He has also advised and prosecuted cases, labor and employment litigation, IP and technology litigation, product liability, manufacturer's defense, factories regulatory compliance, audit advisory and crisis management, international trade, contractual disputes, shareholder disputes, and tortious claims. He has successfully represented several local and multinational clients in the above areas and won several cases, thus dictating the pace in fundamental principles in the Nigerian legal jurisprudence. Obafemi was a member of the expert working group that produced the present Copyright Act of 2022, and was also a member of the Governors Committee for the Reform of the Entertainment Industry in Lagos State, responsible for drafting the legal framework for the actualization of recommendations of the committee. He has been ranked by several reputable organizations like Chambers, Managing IP, Who's Who Legal, amongst others, for his outstanding expertise, and currently sits as the chairperson of the Middle East, Africa, and South Asia Subcommittee of the International Trademarks Association, Inter-Law and Regulatory Committee. Obafemi also serves as a mediator on the World Intellectual Property Organization panel of neutrals, handling copyright and technology disputes, and is a member of the Nigerian Copyright Commission's panel of neutrals, where he has participated as a co-mediator in copyright dispute resolutions. Now, you can see that there's this a very impressive resume. But beyond that, I must thank Mr. Bafemi Agaba for his kindness to us at the TPTA, for his kindness to us whilst we were at the MBA ICLE, which is also continuing now, and generally for his being always available to help train colleagues and mentor them, and at no cost to either the trainees or the institutions that facilitate those trainings. So I think it is important to mention this and to commend him for always supporting the profession. Thank you very much, Mr. Agaba. Now, Nta, I think you should now do the bit before Fabi comes on. Thank you.
Okay, thank you very much, Tobena. Good afternoon, everyone. So just before we start the going to the substantive training, I just wanted to, sound a few housekeeping rules. If you have any questions, please put them into the Q&A section of the chat box. And once the presentation is over, I will come back out to read out the questions so Mr. Agaba can answer them. So just do that. And then please remember that you can watch the recordings again on our YouTube channels. Please follow so so that once any training is dropped on the channel, you are being notified. So we will just go straight into the training. Mr. Agaba, over to you.
Thank you so much, Nta. And thank you so much, Tobena, for your kind words. It's always a pleasure to discuss IP. Good afternoon, ladies and gentlemen. And it is my pleasure to be here to discuss a subject that is a passion for me. The title of today's presentation is IP Enforcement, Emerging Issues and Opportunities in IP. So it looks like we have a 3-in-1 sort of topic to discuss today. Sorry, I'm trying to move my slides. I don't know why. Okay. All right. So, like I said, we're looking at IP enforcement. And I know that in the last 3 days, we have been discussing IP, facilitated by very competent colleagues. Maybe just a bit of setting the background again. What is intellectual property? Perhaps there are some of us that are new totally to the concept of IP, and we thought we should just start from there briefly. What is IP? It is a legal recognition of the right of an individual or a company to claim ownership and exclusively exploit the product of their intellectual or mental exertion. So we're saying that as an individual, it is possible for you to have exerted yourself mentally. You engage your intellectual faculty, as a result of which you have come up with some form of work, some form of product. It could be in the form of an invented product or a new process, creative works for knowledge or entertainment, something of aesthetic value, or insignias of trade. All of these, having produced them with your intellect, are referred to as your intellectual property. Right. Recognize the fact that to have private property and intellectual property has been recognized as part of the private property anybody could have. And this is also at the international level. What is the nature of IP? Because it's very important to understand the nature of IP before we start looking at how you enforce your rights in IP. The nature of IP is essentially something that is incorporeal. It is something that you cannot hold like a physical object. Therefore, it relates to the pieces of information which can be incorporated in tangible objects at the same time and in an unlimited number of copies. The property being the information reflected in those copies and not the copies in themselves. So what we're referring to is when you pick a book of Chinua Achebe, Things Fall Apart. The intellectual property is not the book in itself, which is sold in different places, but rather the content of the book is the incorporeal that we're talking about as intellectual property. So it focuses on the rights which are enjoyed in the product of the mind rather than the product itself. So IP is therefore that body of legal rights which the law has vested in the owner or creator of a particular work. So we've understood the concept of IP. We understand the nature of IP. What is IP law? IP law is simply the law that regulates the creation, the ownership, use, and exploitation of the abstract rights derived from the creative product. In other words, you have exacted your intellect in coming up with a product. And we are saying the law has come into play to regulate who is the owner of this work. How do you determine who the owner is? What is the process of creation? When can you say in law that an intellectual asset has been created? Who is to use it? How does he use it? Can other people use it? Are all the subjects of regulation of the law that comes together to form what is called IP law. So it is the mechanism by which the society protects the interest of the creators by granting them property rights over their creations or inventions emanating from the power of their minds to reason. So that is what IP law is all about, to regulate that area of property ownership. As a lot of us would know, intellectual property has different types. We have what is called patents, we have copyright, we have industrial designs, we have trademark, and there are some other related rights which you talk about, something like confidential information and what have you. But basically, these are the four main types of IP rights. Trademarks. Trademark essentially, as we all might know, is an insignia of identity of a product or a service, and could be in the form of a sign, a device, a label, a name, a signature, word, shape, letter, numeral, or combination of all of these, with the purpose of what? Identifying the source, the origin of a particular product or services. So it can be anything that is graphically represented, that is capable of graphical representation and distinguishing goods and services of one undertaking from another. So if you look at it, trademark is indeed something which we use in the industry, in the business industry, to identify products and identify the origin of products. That is what trademark is all about. And trademark in Nigeria is essentially regulated by the Trademarks Act of 1965, fashioned after the English 1938 Act. And the English 1938 Act, as you would know, has undergone several changes. Even the English people have their own new act, but we are still stuck with their 1938 Act in Nigeria. And we have the trademarks regulation, and of course, the principles of common law also apply to our trademark legal regime in Nigeria. The purpose of today's discourse is to look at enforcement. And so we've defined trademarks. We know the Trademarks Act regulates trademarks in Nigeria. how do you enforce what is called the trademark right? Perhaps the starting point in the enforcement of trademark right is what? Protection of the right in itself. And how do you protect it? By protecting trademark, Section 151 of the Trademark Act has told us that when you have a registered trademark, you are conferred with an exclusive right. What that tells us is that trademark right is one of those IP rights that is subject to what? Formalities, the formality of registration. So the best way you want to start protecting your trademark right is to ensure that you have registered a trademark at the trademark registry in Nigeria. And Section 5.1 of the Trademarks Act tells us quickly that once your trademark is registered, you have an exclusive right to the exploitation of that right to the exclusion of any other person. So enforcement. What happens where a third party then decides to use an identical trademark to yours or a mark that is confusingly similar to your trademark? What recourse do you have in law in terms of enforcing your rights and protecting your rights? Generally, the enforcement of your trademark right may be approached from about three perspectives. One is from a civil court perspective. Two is criminal, and three is what we describe as administrative approach. Okay, administrative or regulatory approach. So the first one we said is a civil court approach. And what you're saying here is that because you have a registered trademark, you are able to go to court for what is called trademark infringement action. Your course of action is trademark infringement. And what you're telling to the court, in essence, is that I have a trademark that is registered. That registered trademark is valid and subsisting on the trademark register as of this day. You then take a step further by saying that the third party is using a mark that is identical to my trademark, or at the very least is using a mark that is confusingly similar to my trademark. And that trademark, he is using it in respect of the same product or the same line of product or business as mine, in a manner to deceive the consumer as if his product emanates from my stable. And once you are able to show to the court all these elements, you are able to sustain a right of action for trademark infringement. At the end of the day, what the law is saying that the third party who uses an identical trademark in respect of identical business or similar line of business is indeed performing what is called deception, and it's causing confusion in the market. And that is one thing the law does not want to encourage. And so you have Section 5.2 giving you a right of action in trademark infringement. What about a situation where your trademark has not been registered? The law says you do not have to fold your hands because your trademark is yet to be registered. What remedy do you have? You have the remedy of passing off in common law. And you would remember that when we're discussing trademark infringement, your legal right that forms the fulcrum of that action is your trademark registration, valid and subsisting. That is your legal right. In common law passing off, there's a legal right you also must establish before the court in order for you to sustain the right of action. And what is this legal right? That legal right is what is called what? Goodwill. The legal right, when you have a cause of action in passing off, your legal right, and it's important to understand that concept, which I'm going to explain. Your legal right there is what is called goodwill. Before we come back to that, what are we saying with passing off as a cause of action? You are essentially saying to the court that, my lord, there has been misrepresentation by the defendant. The representation by the defendant essentially is that he is misrepresenting his product as if they were my product. That representation is being made in the course of trade to prospective customers or the ultimate consumer of the goods, and calculated to injure or take advantage of my goodwill, leading to me suffering some damage. So there are about 5 elements there. So very important to sustain the cause of action and passing off is what we said, goodwill. And what is that goodwill? Because you do not have a registered trademark, you can't sue for infringement. So you come to court for passing off, and the first thing, especially if you want to obtain an injunction, is that the court will say, what is your legal right? Your legal right is the fact that you tell the court that, my lord, I actually have a trademark. This trademark, I have used it in the promotion of my business. I have a business of selling a particular product. And in carrying on that business, I have this trademark, whether it's a logo or it's a name, which I have used in selling this product, which I have used in packaging this product, which I have used in advertising this product, which I have used in carrying on promotional activities for this product. As a result of the use, the advertisement, the promotion of my products using this trademark, my business has become very popular. My business has acquired reputation all over the society, such that when anybody sees that particular trademark, as a result of the use, the amount of promotion, the amount of advertisement that I have deployed using that trademark, my business has acquired goodwill. It is that goodwill that you have shown to the court that is your legal right and the basis for your action in passing off. And once you are able to show this, then the court readjusts its seats to say there is an action to be considered here. And we see all the elements for the thought of passing off. Now, before we go to the criminal area, a fundamental thing you need to understand as an IP lawyer who wants to enforce a trademark right is that you have what is called the bomb of IP. And the bomb of IP is what is called the Atom Pillar Order. Now, the Atom Pillar Order is usually applied for ex parte with an interim injunction. And what are we saying with the Atom Pillar Order? You are telling the court that, my lord, I have seen a situation where somebody is using my trademark in producing products that are identical to mine. I have conducted some investigations and I know where those offending products are. If we do not catch them unawares, they will destroy all the evidence which I need to sustain this action. Therefore, grant me an order of search and seizure. Grant me an order to go to the premises of the defendant unannounced, and let me go in there and be in a position to search their premises and seize the offending products and bring them before you as evidence of the offending activities of the defendant. And that is what is called the Atom Pillar Order. So by its very nature, you apply for it ex parte, and you apply for interim injunction that pending the time I bring, well, these days we file our interlocutory. Pending the time the interlocutory injunction will be had, let them stop any further acts of infringement. This is applied for ex parte, and once the court gives that to you, you are able to go to their premises, to seize this product. How have lawyers used Atompila order? I think we have used it over time beyond the original jurisprudence and jurisprudential rationale for Atompila order. I would not go into such details, but essentially what we need to understand is that it's an order of search and seizure. And the whole idea in an ideal society is that when you have an Atompila order, you are meant to go to the premises unannounced, and once you then announce, say, this is a court order that I have come to what? Execute. Any the right thinking member of the society should obey the court and give you access to do your search and make your seizure. If they refuse, the order is said not to be a break open order for you to go and open up the place without the court order. You are just, if they refuse you entry, you are supposed to go back to court for contempt. How we've done it in practice or how others do it in practice is left for us to know. But essentially, that's the original thought process of jurisprudence behind Atompila order. Now, the second way by which you can enforce your trademark right, I said, is criminal action. And this is usually what you proceed on under the Merchandise Marks of Nigeria, the Merchandise Marks Act in Nigeria. And what the Merchandise Marks Act simply says is that, look, any act of forgery of trademark, false trade description, or manufacturing, sale, or possession of machineries used in forging trademarks or deceptive application and use of trademarks are all acts of crime. And once you know there is a crime, under Section 4, the general powers of the police, you can approach the police to further investigate such acts of crime. And upon their investigations, they can decide whether there is a case to charge to court for prosecution. But beyond this, one of the essence of you taking this approach is that when you submit your petition to the police and the police believe that there is a case here, the police can apply to the magistrate court or to any court that would have the right jurisdiction, apply to the court for a search order as well. And then with that, you can go to the premises to carry out what we refer to as raids to seize the offending products. Okay? This has its own advantages, it has its own disadvantages, but it is important to know that you can resort to a criminal court action under the Merchandise Marks Act, and in this case, you would need the police to tarry along with you. The third way by which you can enforce your action, your right for trademark is regulatory or administrative action. And what do we mean by this? There are some regulatory bodies in Nigeria, and their statutory functions do not necessarily involve intellectual property enforcement. They have their own functions cut out for them. For instance, the Federal Competition and Consumer Protection Commission, FCCPC. You have the Nigerian Customs Service that is to ensure that contrabands do not come into the country and people pay appropriate duties on things being imported or exported. The FCCPC is to ensure healthy competition in the marketplace and make sure that the consumer is not deceived, right? You have NAFDAC that regulates our health. All these, they have their functions cut out for them. But a creative IP lawyer has discovered that in the course of them carrying out their core statutory functions, they could impact positively in the protection of IP rights. For instance, a man who is taking advantage of the trademark of another person is essentially deceiving the market, deceiving the consumers to believe that the product they are buying is coming from Mr. A when they are actually coming from Mr. B. So Mr. A instead of going to court, may decide to approach the FCCPC by a petition to say what this man is doing is an act of consumer deception. And on that basis, the FCCPC can exercise its discretion to take up that matter. So it's a creative way of dealing with some of these trademark issues. And that applies to any other of the regulatory authorities. Once you can find a basis under their law to fight your battle, even though your ultimate goal is fighting your trademark right. So the regulators, we've mentioned some of them. And so very quickly, when you are in court, it's happening, okay. Okay. So your remedies, when you go for the civil court and perhaps even criminal, you can ask for damages, injunctions, seizures and forfeiture of goods, and injunctions to prohibit further infringement. And of course, in the criminal arena, you have penalties and things like that. Okay, so that is as far as your trademark right is concerned. And we have said you can enforce your right from a civil, criminal, or regulatory perspective. Copyright. Copyright is that part of IP law that regulates the creation and use of a range of cultural work, such as novels, poetry, photographs, and what have you. And essentially, copyright is the exclusive right to control the doing in Nigeria of acts such as reproduction, publishing, public performance, translation, adaptation, distribution, broadcast, communication, make available in relation to works in which copyright subsists. What is the point we're making here? We're saying that copyright is that part of IP that protects creative works in the form of information or entertainment in books or novels or poetry, or in the area of visual arts, or even in movies and what have you. And we're saying that copyright is then those rights that have been granted to the creators of this work is the right for others not to use those works without the permission of the owner in any form, like we've mentioned here. And the Copyright Act of 2022 is the law today that regulates this area of IP in conjunction with the principles of common law. I'm not sure I should be going into the eligibility for copyright protection because I suspect that some of my other colleagues would have covered this in the first or second modules. Suffice it to note that copyright, unlike other forms of intellectual property that are generally called industrial property, do not require the formality of registration. And I think I need to emphasize this because this is a problem that has persisted amongst our colleagues, lawyers, and even judges. Trademark needs registration, patent needs registration, industrial design needs registration. And the implication of the registration is that it gives the owner the opportunity to sue for infringement, without which you can't sue for infringement. You probably have recourse to common law. However, copyright does not require registration. And we've seen lawyers come to court a lot of time. The first thing they are saying is that I have copyright, it has been registered, and therefore this man is infringing my right. No, copyright requires no formality. And the new Copyright Act is very express on it now. It doesn't require formality. Okay? And so, what are we saying? The law says that if you create a work and that work in itself is eligible for copyright protection, it enjoys automatic protection without the need for registration. There are 6 categories of work that can enjoy copyright under our law. So your work must first of all fall into one of those 6 categories: literary work, artistic work, musical work, audiovisual work, sound recording, and did I say dramatic work? and broadcast. So if your work doesn't fall into any of these, it's not copyright. And even if it falls into any one of these, it must satisfy originality, fixation, qualification. But once it has all of these in place, you do not need registration in order to enforce that right. What then is the essence of what the Copyright Commission is doing? The Nigerian Copyright Commission merely encourages what is called a depository scheme, where they tell you that once you create a work, you can come to us and deposit a copy of your work. Now, the essence of this copy and what they give to you is merely an acknowledgement of the notification which you have made to them. They are not conferring any registration on you, and they are not the ones telling you whether that work has copyright or not in law. No, they do not confer copyright on your work. Your work has natural copyright if it is eligible in the first place. And if it is not eligible for copyright, by you depositing it there doesn't give it copyright. So they are only keeping records. The records may have some value. Perhaps when there is dispute, it might help you to show by way of timing when you created your work. But it does not necessarily mean that they have conferred copyright on you. And that needs to be understood not just by us lawyers, but even our very revered and learned judges. I think this is something that we should get past completely in Nigeria. It's caused a lot of damage in our jurisprudence, and I think we need to all understand it today. In fact, if there's nothing you will take away from this exercise from a copyright perspective, is to understand that it is not a right that requires registration. How do you then enforce and protect your copyright law? Your copyright, you can do that again from a civil angle and from a criminal or administrative angle as well. In terms of civil enforcement, you can actually go to court to show that somebody has infringed your copyright. Now, the law, I know the former law, and I think the present law also presumes in your favor that the name of the person on the work is the owner of the work. So it is for the other party to disprove that you are not the owner of the work. So you have that presumption. But how do you then establish that the person has infringed your right? Two major elements which are fundamental to the success of your action is what is called opportunity to copy. You must be able to demonstrate before the court that the defendant has had an opportunity of seeing your work, such that it is from that exposure that he may have deduced what he did, and then use that to tell the court that he must have copied my work because he had an opportunity to have seen it. So opportunity to copy is there, and there are ways you establish this. This was one of the things I used when I did the X Factor case, where a Nigerian man had said he was the owner of X Factor. He created the X Factor reality show, and they decided to sue even the owners of the right from the abroad, as we say. And that's Simon Cowell's company. And by the time we went to court to defend our client, Fremantle Media and Cycle, one of the things we established before the court was the thing he submitted before the court. He had a pamphlet which he said was his work that he created X Factor, and had gone to the Nigeria National Library to register it and obtain ISBN number, went to the Copyright Commission and obtained notification, and because of that, he came to court to tell the court he has copyright registration. And we submitted before the court that does not confer any right on him. Two, what he has submitted before the commission is mere concept, which is not eligible for Copyright Commission. But more importantly, in terms of opportunity to copy, we said when he said he created this work, he never published it anywhere. So we could not have seen his work from nowhere. But that he had the opportunity of seeing our work. So if anything, he has infringed our right. And so we counterclaimed. And what we were able to use to establish that was the concept of opportunity to copy, because in the pamphlet it created, it stated herein that the winners of X Factor Nigeria, which he created, will be sent to X Factor America. And the question in cross-examination is, which X Factor America? So you know that it's X Factor America. So it shows that he's had an opportunity of knowing about our work and therefore derived his own concept, therefore opportunity to copy. The second thing that is fundamental in the copyright infringement is what is called substantial copy. Yes, my Lord, he has had an opportunity to see my work and therefore copy it. And my Lord, what he has copied from my work is substantial. The question then becomes, what is substantial in the realm of copyright infringement? Substantiality of copy goes back to the concept of originality. You must demonstrate to the court that what you copied from work is original. And what do we mean by original in copyright law? I believe it has been covered. Original in copyright law does not mean novel, does not mean it is new. It is not a concept of novelty in patent law. You will remember that patent law, under patent law, novelty is a relationship between your invention and the state of the art. But originality in copyright law is a function of your work. Okay? It's the relationship is between you and the work. How is that work peculiar to you? And you want to show that you have deployed reasonable amount of labor, exertion of time, labor, and resources in the creation of the work. So what you are trying to show to the court is that what has been copied is the original part of the work, the essence of your work, which may be in terms of quantity, but in terms of quality. That it might even be a phrase, but that phrase might actually be the real essence of the work, the original part of the work. And once you're able to show to the court, you are costing good in terms of your copyright infringement. Now, copyright may also be enforced from a criminal angle because the Copyright Act has made our copyright officers some form of policemen and given them the power to investigate and arrest for copyright infringement, and they are able to prosecute in court for copyright infringement. Also, they are able to deal with the matters from an administrative perspective by calling the parties together, listening to them, and giving an administrative decision. So just like trademark right, you can also enforce your copyright from a civil perspective, criminal perspective, or administrative perspective. So a patent, we've mentioned what patent. A patent is all about invention. And your invention can be a product and it can be a process. And what you need to show to sustain that you have a patent is that what you have created is new, is novel, okay? It has inventive step and is capable of industrial application. And this is also regulated by the Patents and Designs Act, as well as principles of common law. And you can enforce this right again from a civil angle, because once you have a patent registered, you can then go to court for infringement of your patent or passing off action. And this is one area of the law that I like so much because especially I like to play defense in patent, because most times I go for the kill. The patent you are bringing to me, first of all, I want to attack the validity of that for some other things you would have seen in the action. And of course, sometimes you are able to also deal with your patent issues from a regulatory angle to a large extent as well. Now, today, we can see that the world has changed. And that's why the organizers of this topic were excellent in couching the topic to even include emerging issues. Even in terms of enforcement today, one of the things we would see is online enforcement. Nigeria Internet Registration Association, NIRA, is in charge of domain names in Nigeria today. And when you have infringement actions bordering on domain names, they are able to intervene, look at the matter, and decide the matter one way or the other. So that is another way by which we enforce our IP rights today. So it's important to take note of that. What are the other emerging issues in IP today? AI. The whole world today is talking about AI. And what we are seeing today is that there is a delicate interplay between IP and AI. The questions become, what is the relationship of IP in relation to what? AI. Who owns the works that are generated by what? AI. Is it the machine or whatever you call it that owns it, or is it the human being that put in all the data into the AI to generate it? These are all issues that are generating a lot of conversations, even at the international scene today. Where we are going to land is not so clear. Some countries, I think the EU has come up with some form of regulations, and I think the Nigerian NITDA has also come up with a policy. I think just last month, my firm had a webinar on this subject. Maybe we will share some of the thoughts with the organizers of the program to share with participants. But AI and IP is beginning to generate a lot of delicate issues that we are looking at today as one of the emerging issues in IP. 3D printing and counterfeit manufacturing is another thing we are seeing. Digital piracy, online infringement. You find that as IP lawyers, a lot of our work involves investigations. And I remember as a young lawyer, I used to go to markets a lot, disguising myself as Waterview in order to look at how my clients' marks or products have been infringed or counterfeited. Today, I find that a lot of that work, I don't have to go to physical markets again. A lot are also now done online. You want to check some of your marketplaces, the e-commerce platforms, to be sure that your clients' products are not even being counterfeited on those platforms, or the counterfeits are not being sold there. So you find a lot of work today is gone beyond the overt market, but even on the online market. Data ownership and protection is one of the issues we are seeing today. Data ownership, protection, and that goes even into the question of image rights, merchandising, and all of those are things we're seeing today. In terms of opportunities as an IP lawyer, I think there's a lot. There's a whole lot we can look at as an IP lawyer, and you can decide to pitch your tent in building your career. As an IP lawyer, you may decide that all you want to do is formalities as an IP lawyer. You want to do formalities, or what some people would describe as IP prosecution, whereby all you're doing is registration, protection and registration of IP rights for your clients within your jurisdiction or in any other place. So you're dealing with trademark registration, patent registration, registration of industrial designs, and things like that. You can pitch your tent on that side. And you may decide that what you want to be is what is called a brand protection lawyer, like I like to describe myself. Brand protection lawyer essentially means you are protecting the brands, the identity, the trademark, the patents of your clients. And this is something which you can approach from different angles. Part of your brand protection stems from the administrative proceedings at the trademarks registry, where you deal with opposition proceedings or cancellation proceedings, or upturning a refusal of trademark application. All of these are still acts of brand protection. And then you come to the court again and try to do trademark infringement, passing off patent. All of these are actions of litigation, which are part of what? Brand protection. And in terms of brand protection, you can also be dealing a lot on anti-counterfeiting and illicit trades, carrying out raids, investigations. I think I find it as a very interesting part of IP practice. Beyond IP formalities and brand protection or IP litigation for me is part of brand protection. So beyond IP formalities, IP litigation and brand protection, you may decide to pitch your tent in what is called commercial IP. And commercial IP would involve a whole lot of activities where you are doing IP valuation and you are doing IP alienation of IP rights, whether in terms of creating licenses, assignment, or even using IP in securitization, mortgages, and things like that. And IP audit, IP evaluation are all concepts within the body of a profession you describe as commercial IP. And of course, academia and research. And we've seen a lot of great IP scholars in Nigeria. I give due respect to Professor Adebambo Adewopo. He's a fantastic IP scholar, which I believe a lot of us would know him. Professor Bankole Sodipo is also a leading light as an academia in the IP field. Professor Yemi Lawal of Babcock is another outstanding IP professor. And in terms of IP brand protection lawyers, we also have lawyers you can see to inspire you. Mr. Obatosi Ogunkeye is an excellent IP lawyer. He's my personal mentor from afar. I have not told him officially that he's been my mentor for over 20 years. He's an excellent IP brand protection lawyer. Professor Bankole Sodipo is one. And I didn't say my humble self. I'm also one after over 20 years in the field. So I'm mentioning these names so that we know that this thing is real and there are people you can go to. In terms of IP formalities, you also have excellent lawyers that have done so well over the years. There's Mrs. Oyiku of Jackson and Idu, Mrs. Okrota, Jackson and Idu. There's Miss Lara Kayode of Okayode and Co. And you have younger ones, Tolu, Olaloye. These are names that you can, look up to in trying to build your career in this area of the law. And one of the other things that I must mention in terms of opportunities is IP is not restricted to Nigeria. If you do IP at the highest level, you have international exposures. Some of the work I do in brand protection are cross-border type of work, and you are able to also do IP consultancy for a lot of organizations. I find that I do a lot of work with WIPO and other bodies. So it's an area of the law that presents a whole lot of opportunities, growth opportunities for colleagues. And I think on that note, I would have come to the end of my presentation and hope that I have been able to share some knowledge with us today and also express my profound gratitude to the Practical Training Academy for their kind invite. Thank you so much. Inta, over to you.
Thank you very much, Mr. Agaba. We will have a whole lot of time to take questions. So please send in your questions to the chat Q&A chat box, and I will yeah. Okay, so Mr. Gaba, what everyone was asking for was the slides, that's
I thought I was sharing. I'm so sorry.
no. Yeah.
I wish somebody had mentioned it. I would have corrected that.
But you can still send it, so
No
you can
problems.
share, so we can still yeah. Okay, so first one is the right enjoyed forever? Is there a time frame for rights to expire? So I guess maybe this one you're just going to take trademark rights, copyright rights, patent rights, how long it takes for them to expire.
Yes, the rights are, so it's interesting. The patent right, once you've registered it, is for 20 years for patent. For trademark, I think your first registration is 7 years, and then you renew for 14 years, and 14 years thereafter, you keep renewing, and you can do that for life. In terms of copyright, we have different categories of work, and they have different years. If I remember correctly, your literary work, musical work, some of them have 70 years, 50 years, and some are calculated from the death of the author and things like that. But definitely they have limitations in terms of the enjoyment of the rights. In various degrees, 50 years, 70 years, calculated from the death of the creator of the work.
Okay, so another one, please. Okay, this one is not a question that concerns us. It now says, given that enforcement of IP rights in Nigeria often cuts across agencies like NOTAP, CAC, Customs, and the police, how can Nigeria build an integrated, centralized enforcement framework that avoids overlap and improves compliance efficiency, perhaps modeled after what exists in Europe or South Africa?
Thank you very much for that question. I'm not sure that is essentially is what obtains even in Europe or America. First of all, your IP rights are traditional rights, and they have their enabling laws. And in terms of enforcement, it will be primarily through the courts. And if you're talking about criminal, it would also end up in court through the assistance of the police. Now, if you remember when we mentioned the FCCPC, the Nigerian Customs Service, and NAFDAC, all of these bodies are not IP bodies. Let me reiterate that. They are not IP bodies. They were not established to fight IP rights. They have their statutory powers defined for them. The point we made, however, is that in the course of discharging their statutory functions, they could have the impact, or they could impact on protection of IP rights. And I'll give an example. I remember there was a time in Nigeria that the judges in Nigeria were very skeptical and reluctant in granting atom pillar orders. An atom pillar order is a vital tool of an IP lawyer to catch the man unawares and seize evidence to prosecute his case. So when the judges were not doing this, and it was difficult to enforce IP rights, one of the things we created or we devised as IP lawyers is how else can we protect our clients' right? And so you say to yourself, a man who is presenting his product as if it's Mr. A's product is actually deceiving consumers to buy the wrong thing. And what they are buying may not be real value for their money. So you approach the FCC, then it was called the CPC, Consumer Protection Council. You approach them to intervene, not because of IP, but because of the element of consumer deception. So I think what we then need, I agree to some extent, that we need a bit of cooperation and integration of these bodies when you have a particular action. For instance, the custom seizes a consignment of products that are counterfeit, maybe because appropriate duties have not been paid on those goods. Customs may seize them. But if they have IP element, where the integration and cooperation comes in, is that customs should be able to alert the appropriate authorities that can deal with the IP infringement in that same element. I hope that answers that question.
Okay, so another question is, what is the role of the Registrar of Trademarks in the sustenance of the utilitarian value of trademarks in Nigeria?
That question, I say pass me. It sounds like a serious jurisprudence question. But basically, the trademark registrar is essentially the custodian of the trademarks registry. And he is the person that has been vested with the power to examine trademark applications and determine which passes the test or of registration in Nigeria or should be disentitled from registration in Nigeria. And do not forget that in terms of examining trademark, there are a number of principles which they would have to consider. Is the mark distinctive enough? Is the mark scandalous? Is it an immoral act? All these principles have been stated in the law for him to consider in reaching a decision. And where there has been a publication of trademark application and it's been objected to, there's going to be opposition proceedings. The trademark registrar has the power to decide that. I'm not sure if I've been able to answer your question effectively, unless you want to put in proper context the concept of utilitarian, as mentioned there. And entire is more exposed than me internationally to address that.
Mr. Gala, please. That would be putting me on the spot, but it's okay. Leah, like you said, it's putting us in trouble. So you've answered it perfectly. This other question doesn't really sound because I've been trying to read it and understand it, and I think the person wasn't able to convey his thought very well. But I will read it to you, and then if you understand it or whatever part, you can shed more light. You can provide a response. It's if Copyright Council does not register, why then do they enforce infringement and go as far as taking the copier to court on behalf of the owner? Okay, that makes a bit of sense.
Okay, Mr. Fagbayi, I think I understand your question. Thank you very much. So yes, the Copyright Commission does not register copyright. That is not their duty. They just do a depository system. However, they are able to enforce infringement of copyright because the Copyright Act has given them the power to do so. So it's as simple as that. The Enabling Act has given them the power of investigation and prosecution of copyright violations. It's the law that has given them that power, and so they can do so.
Okay, so the question is, can Anton Pillar order be used in a pending action to recover or claim of property where there is a probable or likelihood of the other party moving away the property or subject matter of the pending action out of the jurisdiction of the court?
Mr. Aliu, so I would say that in law, there are quite a number of preservative orders, and I think Anton Pillar order falls in that category. And another one of such is what is called the Mareva injunction. And I think the situation which you have described there, the Mareva injunction may be more appropriate as the tool to use. And of course, when you have an action in court and you feel that the subject matter of the action may be dissipated by one of the parties and you do not want that to happen, you can approach the court for a Mareva injunction for the court to preserve that property until the litigation is determined. Anton Pillar order is usually more used at the beginning. It's really more of a tool. So from a jurisprudence angle, the real essence of Anton Pillar order is to obtain evidence. And I remember I did a case before Honorable Justice Olayinka Faji about 15 years ago. And I applied for Anton Pillar order. And in my prayer, I wanted to go and seize every infringing thing on the premises of the defendant. But Lord, I was going to say Lord Faji, Justice Faji, in his great wisdom, said, no, Mr. Agaba, I'm going to grant this order. However, I don't even want you to go there with the police. I don't want a scene. Go there and obtain just samples of the infringing product. because the essence of Atompilar order is to come back to court and show evidence that they are indeed doing this thing. But us as lawyers, we have taken it as a strategy that let me go there and seize all the infringing products. Because once I'm able to seize all those things that they have spent money on, I would have crippled their business. And because of that, they are constrained to come and negotiate with me. But the real essence of Atompilar order is to obtain evidence that you can show to the court that they are indeed infringing your right. So in this your situation, a Mareva injunction may be a proper or a better order to go for.
Okay. So, in passing off remedies, since there exists a statutory law in respect of trademark infringement, passing off remedy impliedly became equitable remedy. In view of this reasoning, I'd like the presenter to please consider the equitable dictum that where equity and the law meets, the law prevails, vis-a-vis the statutory law and passing off. I don't know whether this is a question or a comment.
It sounds like some kind of jurisprudence is happening here today. And I think it's good that we are thinking beyond what is the law, but trying to rationalize. And I think infringement is a deduction from the Trademarks Act. Okay, so it's a question of law, as the gentleman rightly proceeds. Passing off as a right of action, I'm not sure is exactly equitable. I would rather describe it as common law and not equity. It's a principle of common law. It's a remedy from common law. The prayers you may ask the court for may be equitable in nature, for instance, injunctions and all of that. But as a concept, passing off is a common law principle where it is not conflicting with the law. It is only creating another right of action for you that where you do not have a trademark infringement. And so let me be like the person who asked the question. There is also the Latin maxim that where there is a wrong, there has to be what? A remedy. So even though I do not have a trademark registration, but I have a trademark that I have labored for, and it is being threatened, I do not have trademark registration, and so I can't sue for infringement. I should be able to have recourse to common law by suing for passing off, if I am able to show that I have the goodwill.
Okay, so this question, if the person was listening, the person would understand it, but I'll just read it out. So the first one is, what are the conditions for eligibility of your work to qualify for copyright automatically? Then 2, please explain the principle of originality. What do you need to show in proving originality, that you are the original owner? Mr. Gaba, I know you've said this before, but please,
Thank you. So for your work to be eligible for copyright protection, the starting point is that you must show that that work falls into one of the 6 categories of works that the Act has said are copyrightable in Nigeria. And what are these? It must be a literary work, or an artistic work, or a dramatic work, or a work of audiovisual, sound recording, or broadcast. So your work must fall into one of these 6 categories. If what you have created is not in any of these 6 categories, that work is not eligible for copyright protection. The Act, in its definition section, has defined what would amount to any of those 6 categories. Right. Now, the law then goes further to say that in respect of artistic, dramatic, and literary work, for them to be eligible, you must show that they have originality and there's fixation. What is fixation? Fixation is to show that that work can be represented in a medium of expression that is reasonably permanent or where we can always find it, within reasonable future. So it's somewhere where we can see it. On paper, it's fixated, on the video, it's fixated, or any other technology that may be able to sustain something for us over time. That's fixation. In terms of originality, copyright says your work must be original. It doesn't mean that the work is new, because copyright does not protect idea. The Lord God Almighty, when he puts an idea, a new idea into the mind of Unta, he has also put that idea in the minds of several other people. The person that takes advantage of that idea is the one that acts fastest, right? So copyright doesn't protect newness of idea. It protects the expression of the idea in a particular manner by that creator. So the efforts, the time, the labor which you have deployed in that your own peculiar or unique expression is the originality that is required in copyright law. And that is why a word is not a subject of copyright. If you just use a phrase or a single word, it's not a subject of copyright, because the law cannot see the exertion of intellect, deployment of labor that you have put into creating a word is not eligible for copyright protection. You must have expressed it in a manner that shows the deployment of your labor, exertion of your intellect to give it an original character. And that is why today you can see the story of, what's the story of that our girl? That our girl that the stepmom was maltreating. I know you read that story several times now. This Oyinbo story, that the girl that Cinderella, thank you. So you can see that a number of authors may have written books on Cinderella. There are different movies on Cinderella. So the story of Cinderella is not necessarily new, but the various creators have expressed it in their own, put their own originality into it. So it's a delicate area, but it doesn't mean newness. It means your own unique expression.
Okay. How can we demonstrate to the court in practical terms how an infringer of a copyright has substantially copied the copyright?
In practical terms, you can demonstrate this to the court. One, by quantity. The amount the person has taken is just too much that you can see that this is coming from this other work. So there could be quantity show of substantial copy. And sometimes it's not quantity in terms of word for word, page for page, but that the main core of your work, the real essence of that work, where the originality of that work really lies. So like I said, there are different stories of Cinderella, but in my own version of Cinderella, the real thing I put in it that gave it my own original character is what you have taken to create yours. So even though it's not the entire story or the entire book, you have taken the original part, and that original part, even though it's limited in quantity, is significant in quality and constitutes the original element of that work, and that you show to the court is enough to sustain your right of action for copyright infringement.
Okay, so just before I ask this question, please, I want to remind everyone to please watch the other recordings, because this question has been answered. And it would also be good for you to subscribe to the YouTube channel so that anytime a new training is done, you are able to actually go there and watch. But this question has been answered before, in previous presentations, but I'll ask it again. It's been asked, so I will take it again. Please, what are the consequences of failure to renew a trademark?
That's a very interesting question. Very, very interesting question. Conceptually, if you fail to renew a trademark, the natural consequence should be that that trademark is no longer valid and subsisting on the trademark register. And if it is not, it means you do not have registered trademark anymore. And you have a right to say, I don't even want this trademark anymore for some reason or the other. So naturally, if you do not renew a trademark and that trademark is taken off the register, it means it's no longer valid and subsisting and cannot be a basis for you to sustain a right of action in trademark infringement. However, if you have failed to register your trademark, there is a duty upon the registrar to actually take steps to take it off the register. And so there has been that debate that where the registrar has failed to do so, it would appear that that mark still remains on the register. And to that extent, there seems to be some form of right until he's taking that positive steps. I don't want to say much because I've had cases on that side and wondering, should I argue it this way? Should I argue it that way? But conceptually, I've told us what the answer is, and what seems to be playing out is another thing we're saying.
Mr. Gaba, in fact, it's a conversation that I was trying to draw Chinasa out to have, and now I think I'll do the same with you. I remember that a couple of years ago, the CAC actually sanitized, took out lots of companies that, were dormant, that hadn't filed, So I'm just trying to, let us imagine if that is done to the trademark register. Mr. Gaba, just imagine what that would do, I would actually really like your comment on that.
Honestly, if the trademark registrar can do that, it would be a great thing to do because there are lots of trademarks lying on that register and causing wahala. And let's go jurisprudence. Let's go jurisprudence. I think I'm a good student. I'm a lover of jurisprudence. What is the jurisprudence behind trademark? Whether we like it or not, trademark is a monopolistic law. So it's an exception to monopoly, right? The law grants you monopoly to use that trademark to the exception of other persons because the law feels that you have deployed your intellect in creating something. And so enjoy this monopoly for this period. However, the law recognizes that the monopoly we are giving you is in the realm of commerce. We want trade and commerce to continue. So when we grant you this monopoly, we know that we are depriving some people of using it. So if you then hold on to a mark which you are not using, and another person feels that that particular mark will be significant in pushing his own business, and you are not doing what you need to do, what you are doing is you are stifling commerce. And so all those marks that are lying on the register that have not been renewed, and some other people have need for them for one reason or the other, the system is stifling commerce. And so the registrar should be bold enough to take them out. And what other advantage comes with that? If you take them out, you're also creating revenue for government because it will be a wake-up call for the owners of those marks to come forward to say, no, I still need this mark. And then they make payments for it. And even if they don't want to, other third parties who are interested can then apply to register that mark. So if I were the registrar today, I would want to make President Tinubu happy that my department is raising revenue. And by taking this action, revenue will be raised by the registry and commerce will also be liberated. So I agree with you, Unta, that is a bold step the registrar needs to take.
Mr. Gaba, other than revenue, for even the government, it's going to actually even bring work to, IP lawyers. For those who, there was a question yesterday, because I'm going to say it again, it's something I have been saying since the beginning, which is for you to be an IP lawyer or for you to practice in any area, it is in the doing. As much as you gain all of this knowledge, you have to do it. So if you do not do it, you're not going to be able to grow in your expertise. And then someone asked, how do you gain clients in the field? And Chinasa gave her opinion, I gave my opinion, and Tobina also gave his opinion. And of course, it's an opinion that I'm hoping that you are also going to you're going to also share. For me, I said that so which is bringing back to the point of, imagine if the trademark registrar is bold enough to actually, publish, because CAC published, if we're going to go down the light of what CAC did, they published all the companies and said, look, anybody within, gave a time frame, and the trademark registrar actually has the right to, to do this. So imagine if this is done to the trademark register, it would actually also bring work to IP lawyers, of course, revenue. So it is a win-win for all parties. And of course, tying down to the fact of how do you grow in this area of expertise. Mr. Gaba, in your presentation, you talked about different areas that a lawyer can specialize in. And of course, this presentation is going to be made available to anyone. It starts in one step. It starts in, you start it, and over time, it's of course going into the angle of philosophy and mind thinking. If you keep thinking about something, you will start seeing the opportunities. You talk to your colleagues. There are people in this field to show you the opportunities. There are very many opportunities. Mr. Gaba, you know that all I have done since, that's why we're friends, is IP, and that is all I do. So if you wanted to, I would actually invite you to actually share more insights as to imagine that if the registrar does this, it will bring opportunities to lawyers who are in this practice area and who also want to come into this practice area. Now, and I know that for CAC, for companies, everybody rushes to go and file their annual returns at the end of the day, because they know that there's a possibility that their mark is going to become, their companies are going to be inactive. So if the trademark registrar can do this, imagine, this is something that I know that you also worked as, you held the position of intellectual property law association. So, what can be done, as lawyers to actually get to a point where, what can we do for this to happen? What pressure can we do for this to happen? Because it has to happen. We really need it to happen.
Oh, I think you've said it all, and I think really it's a question of advocacy, and advocacy. And when I say advocacy, perhaps it's something the registrar may not have thought through. So as individual lawyers, we can approach him to sell the idea to him. Our IP associations, such as ePlan, may also approach him, may also approach the minister in charge of trade and commerce to let them see. And I'm sure that a lot of time when you show government the money and you show government the other advantage to government itself, to creating value for the citizens, I think they would always listen. So I think maybe we are not doing enough advocacy on this area. And if we decide to start doing it, I'm sure something will come up, because there's advantage for everyone in this whole thing. The whole value chain will gain from it. So I think it's advocacy by way of talking to them directly, by way of thought leadership, and we will get there.
Thank you very much, Mr. Gaba. Another question that was asked was, can we file both civil and criminal cases on a single subject matter? I want to believe this is in relevance to intellectual property or maybe copyright and all of that. Yeah. Or brand infringement.
Yes, that is possible. that is possible. You can have simultaneous actions in civil and in criminal. And knowing that, the criminal is not really your action, it belongs to the government or the police, whereas you then pursue the civil action. So it is possible.
Okay, so another question is, do we have a specific law for franchising? I don't know. That was not the subject of our presentation today. But Mr. Gaba, if you would want to.
So franchising is an aspect of commercial IP where you are able to then give out your business model, you license your business model to a third party, and that business model would involve the know-how, the how you carry on the business, to the trademark and order of IPs that are implicit in your business model. I know that we've been discussing a number of things around franchise, but I am not sure that today we indeed have a law dedicated to franchise. I'm not sure. What we have had in recent times is plant varieties, and I know we also have a bill for geographical indications, and of course, the Trademark Act has been a subject of amendment or renewal since I was an undergrad in LASU. One day it will happen.
Yeah, I know that this Notab also had something on franchising when you were bringing in the technology. Yeah, Notab deals with that, and that's not the subject of our presentation today. Another question is, where the registrars are not willing to oblige an applicant, I don't know what this person means, can he approach the court to obtain an order of mandamus to compel the registrar to register his work?
Okay, so where the registrar has made a decision, the Trademark Act provides that you are able to appeal the decision of the registrar. And the appeal lies with the Federal High Court. And I think the mode of commencement is originating motion. Mandamus is indeed another form of enforcement of right, and I imagine that under the general principle, you may want to exercise that right. But in terms of the proper way to appeal a decision of the registrar, that is something which you may be able to do. Because mandamus, to a large extent for me, would be more appropriate in situations where that government body really doesn't have much discretion in doing that thing. The law is very clear. ABC happens, you must do it. In terms of trademark registration, maybe he has some discretion in determining whether this thing really falls within the realm of registration. And I think I probably would go for the regular appeal in such situations.
Okay, so is pirating and copyright synonymous? If not, what are the difference between the two? Secondly, what are the punishments for infringement of a copyright?
So copyright, what it is what it is. Copyright is copyright, and you can infringe copyright. When we talk about piracy, piracy is to copyright the way we say counterfeit in trademark. So piracy is an act of infringement of copyright where you have gone to produce copyrighted works and you are distributing them. Especially in those days where you go and make fake CDs of movies and all of that. Those are acts of privacy. So privacy is an act of infringement of copyright.
Okay, so this is from a young lawyer, and I think we've answered part of this question, but we can answer it again. Good afternoon, sir. As a new wig, is it advisable to specialize in one area of law, such as IP law? And is there a mechanism in place in Nigeria legal system to ensure IP enforcement is possible within a short period of time?
Thank you. My advice to new wigs is no matter what area of the law or what part of the law you want to do, try and stay in a law firm for 5 years. it cooks you up. It prepares you for the future. Even if you want to be a company secretary, legal advisor, you'll find that your experience in a law firm would always give you that edge. And I say, when you're even in a law firm, try and do a bit of litigation. Even if you want to be the best solicitor, best commercial lawyer, or transactional lawyer, your background in litigation, your little exposure in litigation would always add a value. And if you are in a firm that has got a bit of white practice, I always say, as a young lawyer, try and go through the different practice. In my firm, for instance, we have the graduate training program. And when you come in under that program, you are taken to different departments and practice areas to learn different things. And that's what we try to do. So I think you should try and broaden your horizon. And then in the course of that, determine what you really love before you start thinking of specializing. Specializing from day one for me might be too early.
The next question is also the same, is also, what is the advantage? It's more of personal development, career development. What would be what's the advantage of choosing a niche, and how realistic is it to focus on one field and build a career? So I would say that, like Mr. Gaba has said, after you've gone through the different practice area, Mr. Gaba is right, and of course, it's a personal opinion that I also hold, that dispute lawyers are actually the best lawyers, because they get to see all sides of it. You gain a lot as a dispute lawyer, because you're going to court. Today, your matter would be you're defending or you're helping a medical doctor. Tomorrow, your matter could be, something else. So it gives you a broader experience than a solicitor that is just, doing one thing. So yes, it is the same question that this person asked. So it's really the same question. But Mr. Gaba, what I wanted to, I know that, I don't know if you have advice to give. There's always that thing of, not every lawyer, not everyone has an opportunity to go, to land a good firm. So what would your advice be to a young lawyer, who hasn't been able to land a firm that is big, to have, like your firm, to have different practice area? Of course, I had the fortune of, landing a big firm that had different practice areas. But what would your advice be, to some lawyers who don't have the advantage of landing in a big practice? What is your advice to them?
Thank you. I think I have this formula for young lawyers. You have to be hungry for knowledge. And being hungry for knowledge means you have to be an avid reader. You must read very wide. You must do self-development. Self-development is key. It means you want to pick books up and read. And today, there are lots of trainings that are free online. If you want, like in IP, there are lots of WIPO free trainings. There are lots of things. What we are doing today is a free training. It's going to be online. So you have to take advantage of all of those. That is one. Two, mentorship is very key. And for me, mentorship is divided into two. Because you are a lawyer, I think you should find a lawyer somewhere that represents the kind of thing you want to do and approach them formally to be a mentee. And that helps a lot. And I think beyond having a mentor lawyer, also try and have another mentor who is not necessarily a lawyer, but is somebody that is successful in his field and can teach you the tricks of the success of life. So my formula is: be hungry for knowledge, search for knowledge by reading, search for training that can be free, and some are not even free. Expend your money to train yourself, and then look for a mentor in the legal field that can help you, and look for another mentor outside the legal field that can help you. And I think with that, success, with the grace of God, is guaranteed.
You're right, Mr. Gaba. Okay, so one question is, can any of these IP rights be sold by the owner? This is obvious, but
I guess the answer is right. You can assign your right as part of commercialization of your IP rights.
yeah, it is it's something. So you can sell it, and all of that. Yeah.
Just 2 days ago, I had a presentation on commercial IP, and we dealt with how you sell your rights.
Yes, you can sell your rights. It's something that is worth a lot, so you can sell your right. Can an expired or yet to be renewed registered trademark be used in court for purposes of claiming damages against an infringer?
That has not been registered, you might be able to sue under common law, like we said, and you would have remedies you can seek for. And if your trademark has not been renewed and you don't have it subsisting, again, your remedy falls back to common law, and you can still ask for remedies thereon.
Okay, so someone asked, when you talked about copyright, you said copyright doesn't need registration, which I agree. However, how do you prove that your copyright was infringed over someone that has obtained notification for a similar work? What evidence do you supply before the court?
So basically, first of all, you need to establish before the court that notification doesn't give him any right, right? Then two is when you create your work, there are actions which you take that can help you improve it. For instance, some people, when your work is created, you can send it to yourself as an email. When you send it to yourself by way of email, that email is there with the date to show as far as how you created that work. And sometimes you may have used that work one way or the other, and the evidence of use, where you used it, how you used it, is there. And if it's a book that you've published, that evidence is always there of your creation and use of the work.
Okay, so I think this question has been answered, but it asks, question is, can a person use the 3 forms of enforcement at the same time to enforce his rights? That is civil, criminal, and regulatory.
So, like we said, it's possible for you to do so because you are coming from different perspectives. Okay, if I go to the FCCPC, I'm going from a consumer deception perspective. I may not even be. It's even not my action. Maybe I merely drew their attention to something that is happening that is within their statutory powers. But I can sue for infringement for trademark, and the police may also pick up that what this man is doing is a crime. So it is possible.
Okay, so is there any time frame within which IP rights can be enforced? That is to say, the right to sue in IP-related disputes, can they become statute barred?
Interestingly, I think, as enough, I'm trying to remember, but for time becomes of essence, really, really in IP, especially when you want to go for preservative orders, you want to show urgency. And so, in order to be able to show that, you are telling the court that you have just discovered this act of infringement, and that's why you're coming for it. But interestingly, I think it's an issue which I have addressed before, and for some reason, the brain is frozen on that limitation. But we might have something around passing off, which I can't recall right now, I must admit.
Okay, so another question is, does the Copyright Commission have the power to settle disputes internally without taking the matter to court?
Yes, they do that. They do that. And when they settle it, and if you are not satisfied, you have a right to proceed to court. And we've experienced that a lot of time where a client was taken before the Copyright Commission. And if the petitioner is not happy, they still have gone to court. And we have also gone to court. So it's possible.
Okay, so this question may have already been answered, but maybe in another way. Can a company use a trademark as part of the collateral for a loan? And if yes, how can the lender or its agent take over or charge such collateral?
Yes, the answer is yes. And indeed, their documentation would have determined how the security will be realized in the event of any default.
Yes, and at least I think if it's a trademark, of course, if it's used as a collateral, it should be registered with the trademarks registry. Let me see, how do our courts handle cross-border defendants or offshore sellers, service of processes, substituted service, enforcement of foreign judgment? I don't know. Mr. Gaba, do you understand that question?
Suffice to say that you can sue a foreign company, or even a foreign company can sue for trademark infringement in Nigeria. And you can sue a foreign company that is infringing your right here in Nigeria. And the question of enforcement of any judgment which you obtain would become a question of procedure. For instance, is it a country that has reciprocal enforcement arrangement with Nigeria, where you can go in there and register the judgment and it can be enforced? So that's possible.
Okay, where you need to resort to litigation and file Anton Pillar order or Marava injunction, are you required to serve the necessary demand notice as prescribed by the rules before filing a writ and the above ex parte application?
Well, I think for me, if you're going to court for an ex parte action, that's an ex parte action. But before you get to the ex parte or the core action, most times in IP matters, you probably would have served a cease and desist letter. And your cease and desist letter may probably be in the nature of satisfying your pre-action protocols.
I'm just trying to, because some of the questions, so I'm trying to take the ones that are relevant. So for this question about can a genetically modification be protected by copyright? The Copyright Act has actually listed out what is protectable. So, and so if my creative work has a slight resemblance with someone's creative work, and the original creator sue me for copying his work? This question has been answered by Mr. Gaba.
It's a question of substantial copy, it's a question of originality, it's a question of opportunity to copy. If those facts are established, it might be able to sue you, and it depends. So it's preponderance of evidence and the factual situation.
So please, I would like to encourage everyone to listen to the training from Wednesday and Thursday, because most of these questions were addressed by that presentation. So the first question of what is the validity of a registered trademark, and in fact, Mr. Gaba has actually answered that. The validity, first instance, you register, it's protected for 7 years. After that, you renew for another 14 years. And after that, you renew in perpetuity. You can renew it for as long as, lifetime, whenever. You just keep renewing. So another one is also failure to renew a trademark for the owners makes the mark to fall into the public domain. Is that correct? No. No, it's not. So the next question is, in enforcing a person's rights, can the person implore the three? Yes, we've answered that. You can implore the three civil, criminal, and regulatory. Mr. Gaba, I'm right on that, right?
Sure.
Yes. So is there a difference between plagiarism and copyright infringement?
Plagiarism can be a form of copyright infringement because really it's a question of copying another person's work.
Okay, so this question is not a question that we can take here, but it is an interesting question. It is mentioned yesterday that it takes a minimum of 2 years to register a trademark. The registrar will have to work on his turnaround time. The registrar is a public servant, so I'm sure if you send him, um, you can send, he's a public servant, so he has a right to listen to you. So you can send him a letter on that, and all of that. So it's not something we can discuss here. How best would you recommend that an expense app developed? No, this is not a question that we can take here. Can a lawyer interested in IP get a virtual internship training in IP? Oh no, that's not a question we can answer here. Okay, this one is saying thank you. Moji Rayo. Yeah, thank you very much. Let me see. Can a soft copy of okay, that I want to believe that we have. Okay, so is it necessary for an IP right over a musical act, such as songs, be registered to be valid? Mr. Kaba has said it, and all the presentations before now, IP rights is not registered. It's just copyright. The fact that you've done copyright notification, it doesn't mean registration. Once you've created something that is eligible for copyright, it attaches automatically. What usually just happens is, most people go to the Copyright Commission encourages you to do copyright notification for it. So that's just it. But once you've created something that is eligible for copyright, it attaches automatically. Please, the YouTube channel has all the Tabina, please, can the YouTube channel link be posted on the chat box like it was done yesterday? Because
Isn't it there? Okay, I'll get them to post it.
yeah, how can you access to the YouTube channel? I think we have answered most of all the questions that are relevant to, of course, the other questions are can we have slides? They are on the YouTube channel. And once it's posted on the YouTube channel, the slides, as Mr. Gaba was going through it, will show, and the slides will be sent out. We have just about 13 minutes. So Tobina, do you have any comments before we round up?
Yeah, before saying thank you, Femi, I just wanted to say that the reason why we do what we do here, especially at the Practical Training Academy, and indeed with the MBA ICLE, is that we have a huge problem, a big problem in Nigeria in the legal profession. This year alone, 10,000 lawyers were admitted into the profession, and a lot of them don't have mentorship, pupillage opportunities, and an opportunity to learn the trade other than what they've had in school. And then also, and critically, we also find that we are more focused on litigation practice across Nigeria than other areas of law. So we find that we are not flogging other areas as much as we should. And so quite apart from the desire to keep improving ourselves all the time through trainings and development, there's also that idea around expanding the practice space so that people start getting enlightened about what is in existence and what is possible. Because if you really don't know about opportunities, they could pass you by and you wouldn't even know that this is law we're talking about. So, so the real thing for me is we have a lot of Nigerian young lawyers in Nigeria and some older ones who are not earning enough money, who would like to expand and diversify their practice areas. Now, just looking at your CV alone, one could see that you've, and of course, people have asked questions about specialization, but it was interesting to see what your focus areas were, from the trade disputes to IP litigation and all of that. And you could see the connection between them to the thoughts that manufacturers' liability and all of that, that also relate to basically the same trend or type of commercial litigation. Now, the question I ask as far as IP is concerned is just in very practical ways. What do you think that lawyer in Onitsha or Aba or Sokoto or KB should do to get himself on the ladder? I know you talked about mentorship before, training and all of that, but if you could do this as the last point that people could reflect on before leaving the session, I think we'll be delighted. Thank you.
Thank you very much, Tobina. I think it's pretty much simple. If you remember when we were young lawyers, a lot of us used to go to the courtrooms to sit down and watch proceedings. I don't know if young lawyers do that now. We used to go to court and just sit down and watch proceedings. And that was how I got to know quite a number of SANs back then and listen to them. In fact, arguing interlocutory injunctions was me watching people like Alhaji Femi Okunu in court live. And that was where it stuck to my head, that thing called balance of convenience. So first of all, for those of us who are in remote areas, and you have people who come to those jurisdictions to argue on cases in areas of cases that you are interested in, sit back in court. The courtroom is not a place where you rush in and rush out to do your case. The courtroom is a classroom for lawyers, and our job is called practice for a reason. If you don't practice it and watch practice, you don't learn. Even as we remain lawyers and we remain students forever. So I think that the opportunity of cases you do not do, but come to court when you are in court, presents an opportunity for you to learn. That is for sure. Secondly, is the fact that once things are filed in court, they become public documents. When you are in court and you witness a case of interest, go back and apply for CTC of those court processes and use the court processes to learn how things are pleaded and all of that. And of course, trainings like this, people need to engage in them. And like I said, a lawyer must always invest in self-development. You have to buy books, create time to read this book, internalize what is there, and do not be ashamed in socializing with colleagues. If you have case and you know a subject matter expert, seek their what's it called? Their interventions to take one. I've had a lot of lawyers consult me, not even with a charge. Or I have this IP issue, can we discuss it? I have discussed with other lawyers in other areas as well. So I think it's important to always learn from the courtroom. It's important to do self-development by investing in materials and taking the time to read them and looking at precedents from court, I think are all important.
Thank you very much, Femi. Thank you. Very useful insights. Before saying the final thank you, I just want to acknowledge the presence of Mrs. Sarah Omega, the director of MBA ICLE. Sarah, nice to have you here. And just to remind everybody that these trainings are monitored, and I expect that before the end of the day or so, MBA ICLE certificates to be issued to you. But fundamentally, I just want to say to everybody that, and I'm happy that the session has been very interactive, and it shows that people are here for the right reason, not just to pick up the CPD points, but actually to engage and to learn, because fundamentally that is what the Practical Training Academy is about. So thank you very much for that. And Femi, well, again, fantastic delivery, fantastic session, very, very illuminating from every dimension. And it also shows that in every aspect of law, where there's transaction, there's also the litigation aspect of it. And you've just helped bring what people have learned in the first 2 days together. And it was fantastic. Thank you very much. And I just want to say to everybody that we're always delighted to have people like Femi who want to give back and continue to give back. I mean, when somebody gives of his time without asking for any recompense, just to see that others develop, I don't think there's anything more enriching than that. And we are extremely grateful to you for this. Thank you very much, Femi, for this and for all the other times that you've supported our initiatives. God bless you.
Amen. Thank you very much. It's been a pleasure. And thank you for the opportunity. Nta is my friend for life.
Thank you very much.
Same here.
So thank you very much. Enjoy yourself in that part of the world.
So we have another training. So the last training is on Monday, same time. It will be on copyrights, in depth. It will be taken by Mrs. Ngozi Adirigbe. So please, we're encouraged to come along and be part of the session. It's also from 3 to 5 p.m. Nigerian time.
Yeah, can you see the YouTube link now? Can you ask for it? Can you see it on the
Yeah,
chat box?
those asking for it, yes. It is
Okay.
in the chat now.
All right, great stuff. Thank you, everybody, and do have a great and blessed weekend, and see you on Monday, all things being equal.
Okay.
Take care.
Thank you.
Bye-bye.
Bye.
Thank you. Bye-bye.